Can states, consistent with Title IX and the Equal Protection Clause, designate separate women's and girls' sports teams based on biological sex? That question goes to the heart of the issue that the Supreme Court agreed to hear in two of arguably the most important cases this term, West Virginia versus B.P.J. and Little versus Hecox. But let's ask that question another way. Can states protect women by reserving female sports for, well, females? If we asked that question 20 years ago, I doubt there would have been much disagreement. But we're not 20 years ago. We're here. This is where the fight is. And in ADF fashion, we're supporting the states as they defend their rights to protect women. I'm Andrew Spangenburg of Alliance Defending Freedom, and what I just described is the legal question. But behind it are real consequences, real people. And to walk through all of that with me, I'm joined by two colleagues who've been working directly on these issues and can help bring some clarity to what's happening right now. Kristen Waggoner is ADF CEO, President, and Chief Counsel, truly at the tip of the spear when it comes to these issues. Chris Schandevel is Senior Counsel on ADF's Appellate Advocacy team and has played a critical role in getting these arguments before the Supreme Court. Kristen, Chris, thanks for joining me.
Happy to be here.
These cases are huge. They're significant in a lot of ways. I know that, you know that. But for someone who might not be familiar with these cases, what do you say to them to explain the importance of why they matter?
Well, I think the first thing that I would think about as those who are interested in truth being in the law, that they're about the concept of truth, whether it exists and whether our law will reflect that. In terms of the legal issue, there are a couple of different arguments that are being made, one based on a federal statute, Title IX, the other being made on the Equal Protection Clause. And essentially, at bottom, it's about whether the Supreme Court will affirm the right of states to be able to make distinctions based on sex when those distinctions matter.
All right, so there's two different cases here. So two states, two state laws, two lawsuits. Walk us through both of those laws. Can we start with West Virginia?
Sure. In West Virginia, the case is commonly referred to as the B.P.J. case, which reflects an 11-year-old boy who identified as a girl who filed a lawsuit after West Virginia passed a law protecting women's sports. And that was about 2021 when that law was passed, and the lawsuit was actually filed before the law even went into effect. In terms of what our role is in this case, and a similar role in the Idaho case as well, is that we represent both the state, West Virginia, but we also represent a female athlete. Lainey is the female athlete in that case, and she bravely has stood for women's sports. She was a collegiate athlete. We also have represented another young woman named Adelea, who has been affiliated with a different case, but also subjected to having a boy identified as a girl on her team, displacing her, and also to sexual harassment. So those are the athletes that we represent, the victims in this case. And in terms of the law, the West Virginia law that's at issue basically says that boys can not compete in girls' sports. And yet they also can compete on male teams or co-ed teams. And girls can compete on boys' teams. And that's because Idaho and West Virginia are looking at the biological distinctions, the physiological distinctions between boys and girls, and ensuring that girls are not going to be sidelined in their own sports.
I met Lainey. She's phenomenal. Even Maddie, I met them. They're great. Now, just to be clear on this, and Chris, maybe this is a question for you. A biological female can, in both laws, they could try out for any team. It's just biological males cannot try out for any team, right?
That's right. So both laws share certain things in common. Both laws say that any competitive sports teams in the states of Idaho and Little versus Hecox, or West Virginia in the B.P.J. case, any sports teams at the college level or secondary school level have to be defined, distinguished based on male teams, female teams, or co-ed teams. And so for the male teams or the co-ed teams, boys or girls, men or women, can try out for those teams, compete in those teams. But it's the women's sports teams and the girls' sports teams where we're concerned about boys and men coming into those teams, dominating those sports, and taking opportunities away from women and girls. So both laws say that for girls and women's sports teams, only girls and women are allowed to compete in those sports.
Now, I read the opposition's briefs, and they talk a lot about discrimination against transgender people. So let me throw a hypothetical at you. A biological girl who identifies as a male, where can she try out? Any team?
Yeah, that biological girl who identifies as a male because she's biologically a girl can compete on the girls' teams. But because these laws do not prevent anyone, regardless of gender identity, from trying out for and playing and competing on the men's and the boys' teams, that girl could try out and compete on those teams as well. Gender identity does not matter to these laws. All that matters is biological sex, for the simple reason that gender identity does not matter in terms of fundamental fairness and athletic abilities. Again, all that matters is biological sex, which is why the laws make sex-based lines and not gender identity-based lines.
So I'm not going to lie, these laws sound reasonable to me, but that's no surprise. I work at ADF. But it doesn't sound reasonable to everyone, apparently. Who's challenging these laws, and why are they challenging them?
Well, we've heard a little bit about the plaintiff in the B.P.J. case.
Right.
I'll say a little bit about the Hecox case.
Right.
So the Idaho case is called Hecox versus Little. The plaintiff who brought the lawsuit there alongside the ACLU, Hecox is a college athlete, a biologically male athlete who identifies as female and decided as a college athlete, I want to identify as female and compete against women and girls. And so Hecox actually testified against the law before it was passed. 16 days after the law was passed, filed a lawsuit to try to get the law enjoined across the state from applying to any male athletes who want to compete in female sports. Won that injunction, got the law put on hold, and then we've been litigating the case since 2020 for those 4 years now.
Now, there's a lot of good state laws out there to touch a lot of different issues, okay? But we're not jumping in the fray on all of them. Why these cases? What's at risk here that warrants ADF jumping in to help out?
Well, I mean, first of all, it's fairness. Like, that's the obvious piece of this, is fairness for girls and equal opportunities. And we'll talk more about the legal arguments and what Title IX has to do with that and the purpose of it. But I mean, that's the bottom level. Girls are getting pushed off podiums. They're also losing scholarships. And, you know, one of our clients, for example, that's how she got into college and made her way through college to become a nurse. And you know, all of the success she's had was because she was able to get a scholarship through an athletics program. When men come in and they take away those scholarships, which is what happens, because there's a limited number of them available, then girls are denied those opportunities. So it's basic fairness about podiums, winning, having equal opportunities, not giving our girls lessons in losing.
Right.
You know, you want as a parent to be able to have your girls tie their hard work to success. And that's not what will happen on the athletic field if boys are allowed to compete on there. There are a number of other implications that we'll talk about as well, but that starts with just basic fairness and equal opportunity.
Someone who's got 3 girls myself, that's huge, right? But anything else? I mean, what about privacy?
Yeah, in addition to fundamental fairness, we're seeing privacy issues and real safety issues arising around the country from states that have allowed men and boys to compete in female sports. So I'll give a couple of examples. In West Virginia specifically, Appellate Cross, one of the clients that Kristen mentioned earlier that we represent, she has been forced to share a locker room with B.P.J., with the plaintiff in the B.P.J. case out of West Virginia. As a result of that, she's been subjected to sexual harassment from B.P.J., very explicit sexual comments inside the locker room, which even got so bad that she was forced to change for her track and cross country teams in a bathroom separately to try her best to avoid that sexual harassment. But what the other side's position in this case is that states can do nothing to protect girls like Adelea. States can do nothing to prevent boys, male athletes like B.P.J., from being in very private spaces with women and girls who are very vulnerable when you allow men and boys into those settings.
Again, I'm not going to hide where I stand on this issue. Why doesn't it stop there? And you kind of went into it already, what the other side is saying, but they can't just say that. What legal arguments are they trying to put forth that says they win? I mean, it seems kind of, based on how you've just laid it out, it seems kind of like they don't have a legal argument. What are they saying?
It's pretty convoluted, Andrew. I got to just give you that. I think that essentially what they're saying is that there is sex discrimination that occurs, and that the category of female essentially should include boys who identify as girls. I mean, that's like very baseline. It's a lot more convoluted in terms of how they're saying it, but that is what they're saying in order to get a higher level of scrutiny. They're also arguing for, that transgender status is a suspect class. There are a number of arguments that they're making to try to get there. And one of the reasons that they have to strain so hard to get there is because the science and practical experience demonstrates that there is a reasonable, rational reason for making these distinctions. I just want to hit on one more thing before we move on from the practical distinctions between the cases and what's actually happened. So one example or difference between the cases, you might say, is that B.P.J. Argues that B.P.J. was placed on puberty blockers and so has not undergone puberty because of the age that he was where he started identifying as a girl. And that makes the West Virginia case a little bit different than the Idaho case. And so they would argue that the court should be applying the law sort of specific to B.P.J. under a number of different legal issues, but based on that puberty blocker issue in part. And what we know is that, first of all, medication, there's no amount of testosterone suppressant that's going to make it so that it's an even playing field between a boy and a girl. And the second thing is the same thing, the science plays out in the puberty blocker context. Boys who haven't undergone puberty, they still throw harder, they still are swimming faster, they physiologically, anatomically are made differently.
Right.
And we know that that's because that's the way God makes us.
Amen.
And the last thing I just want to say that about how we know that is we can even look at B.P.J.'s performance record. So the case started when he was 11 years old, and several years have passed now. And what we have seen that over 400 girls have been displaced and beaten over 1,100 times by this boy.
That's just one.
And 57 medals have gone to the boy. And that's a boy that has supposedly been on puberty blockers during the course of his life. So we know both practically and scientifically that there are distinctions that need to be made.
I feel like I don't even have to add to that. I mean, it just speaks for itself. What about in Hecox, though?
So similarly in Hecox, the science is not backing up the claims that the other side is making. So even assuming that the way that you were supposed to do the constitutional analysis in the equal protection and context for a sex-based distinction, their argument is basically we should be doing this as a form of strict scrutiny. That if even a boy was similarly situated to the average girl, you have to let that one boy play female sports. That would turn intermediate scrutiny on its head and turn it into strict scrutiny. So that's just not the way the test works on a legal basis to start with. But even kind of granting them that premise, even if we did do the analysis that way, the scientific basis for Hecox's claim all along has been, well, I've been on puberty blockers for a year, so even though I went through all the advantages of male puberty, because I've suppressed my testosterone levels by taking these drugs for a year, that makes me comparable to the average girl. Unfortunately for Hecox, the record in this case and even the science that the other side is relying on don't back up that claim. Just taking the science first, their own expert's testimony relies on a study that shows 3/4 of the males who took testosterone suppression to lower their levels were not able to lower their levels to the average female level. So only a fourth of the participants in that study. And it actually turns out the fourth that were able to lower their levels that much, they were the most out of shape participants in the study, which is not the type of people that we're talking about. We're talking about athletes here, and the participants who were in better shape, their levels stayed higher, those male participants. But secondly, what we know from Hecox's own statements in the record in this case, Hecox said, well, I was on these drugs for a year, and that was able to bring my testosterone levels down almost to the level that would have allowed me to play under the Olympic rules. Well, if you look under the Olympic rules, what you realize is their levels required a testosterone level that was 6 times higher than the average female level. So even Hecox's best evidence that Hecox and the ACLU can muster shows that Hecox's levels were still 6 times higher than the average female level at the time that Hecox filed the injunction that put this law on hold across the state. So the law doesn't back up their claims, and the science don't back up their claims either.
They almost have to make these arguments, right? I mean, if they say, look at all males generally, it falls apart even faster. It still falls apart. But they are arguing that there's some type of magic pill or drug that kind of, if you take it, my testosterone goes down and I can get to these levels, but the science doesn't agree with that. Not everyone agrees with that, right? What have other states done with this or other organizations?
Well, it's been pretty phenomenal to watch it over the course of the last 10 years. I mean, ADF first started getting involved in the issue of gender ideology as it applies to women's locker rooms, bathrooms, and those kinds of things in about 2014, 2015. And then quickly moved into filing the first lawsuit in Connecticut on behalf of some high school track athletes and complaints with the Office of Civil Rights as well. when I look back to that and where things were and organizations were then to where they are now, it has been a complete 180 in terms of the changes that we're seeing. We could start with the NCAA's policy and how they were extremely hostile to women and to equal opportunity in the beginning. We can look at even our clients in the high school case, the Seoul case, where they couldn't get their coaches to speak up for them. They couldn't get their athletic association. They couldn't get feminist groups to speak up for them. And they came to us. And now we're seeing a lot more feminists and others who are not ideologically aligned on many issues, willing to stand for truth. We've seen it in the Olympics and the changes that we're seeing in those Olympic standards in other athletic associations as well. And lastly, and I think most significantly, we're seeing the states stand up. 27 states have now passed laws, and we've been able to help them do that by helping write those laws, helping get those laws passed, and then defending those as we're doing here. So we are extremely thankful for strong attorneys general, like West Virginia's and Idaho's here. This does not happen without strong public officials taking a stand.
We're surrounded by heroes. I'm gonna be honest with you. Every client that I've seen that we've defended, that I've interviewed, they're just heroes. And on and off set, they're courageous. You see it in their eyes, and they love the Lord. I don't know if you've noticed that. I'm sure you have.
Yeah.
All right.
That shows what's at stake in this case, right?
Doesn't it? Yeah.
Because a ruling against West Virginia and a ruling against Idaho would pull the rug out from under all of those brave clients that we've represented that have stood up for basic fairness and privacy and safety for women and girls.
And the 27 states.
It would pull the rug out from under those 27 states and say constitutionally and under federal law, you are not allowed to protect women's sports in your states.
Wow.
And I think so many times we think about what a win means, but we don't think about what a loss would mean.
Right.
And so, yes, we need to protect the 27 states, but as Chris just highlighted, what about the other 23 too? Like if we lose the 27 state issue, we've lost the 23 states as well.
Yeah.
It's critical to win this case.
Absolutely. So there's no doubt that this case is important, but it is only about sports. But what other contexts do these sex differences touch on? Surely there's more.
So much of our work has been based on having to combat this gender ideology. I had a question come from a reporter a couple weeks ago that said, you're being accused at ADF of being in all these cases to combat gender ideology. Why are you engaged in this as if we are the aggressors?
Right.
And the response is no, there is a radical ideology that is being put forth in our culture and has really rooted in our law, and we have to uproot that.
Yep.
It affects women in terms of not just sports, but our locker rooms, our showers. I mean, what we're seeing online right now happening across this country in terms of just the privacy that we have, our safety, not just in getting a concussion as Peyton McNabb did in volleyball, but safety in our private spaces. And then women's shelters as well, domestic violence shelters, all of these areas. And I don't want to leave, and I think Chris will probably talk more about this too, the issue of our speech. I mean, so much of our work, our religious freedom, our right to to speak freely is tied up intricately in what happens with this gender ideology and whether we can uproot it from the law.
And a lot of these women are girls, right? They're young, high school. Again, I'm thinking my kids aren't quite at that age yet, but they're getting there. And that's hard to think about.
Yeah. We at ADF stand for everyone's ability to hear and speak the truth. And this is one particular battleground where truth is at stake. And so ADF decided that we're going to stand up for truth, that God created each of us male and female, that he created us differently, and that those differences are worth celebrating. That even Justice Ginsburg, in her opinion, in one of the cases that we litigate in this space, said that there are basic biological differences between men and women. They are inherent, they are physical, and they're worth celebrating, not to be destroyed and pretending like they don't exist. Which is what the other side is trying to do in these cases. So that's a very important truth that we're standing for that, like Kristen just shared, has implications much more broadly than just these cases.
And I would also just say implications for families, for rights of parents. We have a half dozen cases right now where, at least a half dozen, where children are being secretly transitioned in the public school system behind their parents' backs, where we have been involved in a number of situations where children have been transitioned and they're detransitioning now. We can do everything we can to bring restoration and redemption, and we believe that God can do those and heal those wounds. But let's be honest, when you've mutilated your body,
Yeah, I know.
those things don't, you don't restore that in the way that it was meant to be. And so the victims in this have to be front and center for all of us and give us more courage to stand.
Yeah.
One thing you mentioned, just go back, you said ADF decided to stand for the truth. But I think to add to that, ADF decided to stand for the truth long before this issue came up. Like I mentioned earlier, like 20 years ago, you back and you asked this question, and no one's gonna disagree with you. It's like Daniel, and he purposed in his heart before the question came. Now, ADF, I think that's why ADF is one of the few, I have to say one of the few, that has stood up against this from the beginning.
Yeah. Because from the very beginning of time, the very beginning of creation, we've seen the harm and the damage that is done when lies are told and not confronted. You know, Adam and Eve's fall in the garden was based on believing a lie. And so when ADF saw this lie being told, that your sex doesn't matter, how you were created doesn't matter, that all that matters is whether you identify, whether you feel like you want to be a girl or you feel like you want to be a boy, we knew that if that lie was allowed to be not just told, but if those who believe the truth about how we're created are silenced and not allowed to speak the truth, we knew that there would be great harm that would be done. And we've seen that harm being done with our kids and the schools, the parents we represent, the detransitioners that Kristen mentioned earlier. And so this case, if the other side were to win, again, talking about the impact of a loss, the other side were to win, that would be the Supreme Court enshrining into federal law, enshrining into constitutional law, the lie that gender identity should be treated just the same as sex, that it doesn't really matter how you were created, that what really matters is how you identify, how you see yourself. And enshrining that lie into law would have serious negative implications for Americans throughout the country for decades to come.
We could definitely dwell on this, but I need to move us on. Sorry about that.
Yeah.
So I get why these cases are important, but the court can't decide these cases purely on policy arguments, right? What are the key legal arguments? Can we start with Hecox?
Sure, let's do that. So Hecox is going to be argued first in the courtroom. So you'll hear the Solicitor General of Idaho, Alan Hurst, get up and make that argument. So we're co-counseling with the state of Idaho in that case. So the first issue that's likely going to be on the table for the justices is the issue of mootness. And so that's a procedural issue. I don't want to go too far into the procedural weeds, but just to give you some of the backstory there. So Hecox started this case when Hecox was a sophomore in college and said, I really want to try out for the track cross country team, and so I need this law to be put on hold so I can run on the girls team. Got the law put on hold. Hecox tried out for the team, didn't make the team, then subsequently dropped out of school entirely. And we saw that and said, well, maybe this case, is Hecox going to come back? What's the status here? And Hecox said, no, I plan to come back. I'll plan to try out again. I want to keep playing sports. I want to keep playing sports, keep this case alive. So we litigated this case for 4 years, back and forth. The entire time, Hecox won at the district court level, won at the Ninth Circuit Court of Appeals, and then we appealed the case to the U.S. Supreme Court, and the U.S. Supreme Court decides to hear the case. And then what the Supreme Court did after that was they just decided the Scarametti case, the case out of Tennessee, involving these dangerous so-called sex change drugs for minors. And that case went against the transgender rights activist side. And so what we saw after that decision, immediately after, was Hecox's team at the ACLU filed a brief in the Supreme Court saying, actually, Hecox has had a change of heart. Hecox no longer wants to play women's sports, and Hecox would like this case to just go away. So you should dismiss this case because the case is moot. There's no longer a live controversy. So we have said, well, that's convenient timing. That it's not until the case is about to be decided by the U.S. Supreme Court that Hecox has lost all interest in playing women's sports. So we have taken the position that this case is very much still a live case with a live legal issue. Hecox could decide to keep playing women's sports tomorrow if the court were to rule in Hecox's favor. So Hecox has an interest in this case. But beyond that, there's a real concern about gamesmanship in this case, that if the Supreme Court allows Hecox to get out of a case like this because maybe the ACLU is worried about getting a bad ruling, what is that going to do to every case that comes to the Supreme Court where a party decides, oh no, oral argument didn't go well, maybe we're going to get a bad outcome, maybe we should just file something with the court and say we no longer have an interest here. I mean, think about, just to make it more concrete for the audience, think about the Dobbs case. That decision leaked months before the final opinion came out. What if the abortion clinic in that case had said, actually, we've decided we don't want to do post-15-week abortions anymore. We'd like to just get out of the space completely. We don't have any interest in this case. You have to dismiss this case instead of issuing an opinion. We would have never gotten Dobbs if that kind of tactic was allowed to occur in that case. And that's why we think the Supreme Court really needs to step in and say, no, we're not going to allow that kind of gamesmanship in a case like this where the parties in the case still have a live interest in the outcome.
Nothing says confidence like, let me dismiss my own case.
Exactly.
All right, so that's the procedural issue.
Sure.
What about the merits? Let's just assume the court says, all right, I see through the argument you're trying to make. Merits.
Sure.
What do you got?
So on the merits, one of the legal differences between Hecox and B.P.J. is that Hecox only raises the equal protection issue, whereas B.P.J. raises both. So in Hecox, equal protection issue, the equal protection clause, the main purpose served by that clause is to make sure that similarly situated people are not treated differently. So you don't want, two women who walk in for a job, or a man and a woman even who walk in for a job and are equally qualified. You don't want the employer, you don't want the government saying, well, we're going to treat the man and the woman different, even though they're equally qualified for this employment opportunity. But in spaces where differences do matter, and there are good faith reasons to draw distinctions, like the sports context where there are very physical differences, our position has been, and we think the science clearly bears it out, common sense does, that men and women are not similarly situated when it comes to their athletic abilities and participating in sports. So we think it's very clear that the Equal Protection Clause allows for lines to be drawn in the sports context, in the locker room context, in the bathroom context, women's shelters, et cetera, where these differences matter. And so that's the question on the equal protection. The constitutional question is whether or not men and women, boys and girls, are similarly situated.
But are they really arguing that? Aren't they saying, I'm going to oversimplify this, but aren't they saying, no, court, look at me only, don't look at all men?
So
generally?
That has been their argument.
Okay.
And in order to be able to make that argument, they have to get the court to buy this idea that sex-based distinctions under the Constitution, that you don't do a broad analysis based on all men and all women or all boys and all girls, but you actually go down to individuals and decide whether individuals are entitled to an exception. And that's where we get back to just completely turning intermediate scrutiny on its head, because that turns it into strict scrutiny, and the courts have never required that. And if they did, that would mean the end of women's sports, because there's no way to draw those kinds of administrable lines that would preserve fairness and safety for women and girls.
I mean, they're arguing what they have to argue. It's a stretch.
Sure.
But unlike Hecox, Title IX is at issue in B.P.J. Can you tell us more about Title IX?
Yes, happy to. And I will also just note that rational basis is the appropriate standard under the Equal Protection Clause for this to apply. So while they are aiming for intermediate scrutiny, they don't even get there.
Right.
So that's good news for all of us, I think, and we'll hear some about that in the argument. On the Title IX issue, the Title IX is a federal statute. It was put in place in 1972, over 50 years ago, to ensure that women have equal opportunities in educational programs where federal funds are being given. The reason for that was that women were not being given equal opportunities. I think it's easy, over the last 10 years, we've talked about it all in the context of sports. But back then, one of the big issues was also curriculum. What classes women were allowed to take in high school and in college, what majors they could participate in. Think of all of the different areas that educational programs serve men and women. And women were boxed out a lot of those. So that statute has really helped to equal the playing field and give the opportunities to our daughters and our sisters, the same qualitative opportunities that are given to our sons and to our brothers. And that's the right and fair thing to do. In addition, under the Title IX statute itself, it makes sex distinctions. So while the statute says you can't discriminate on the basis of sex, it also permits sex-based distinctions when those distinctions matter. Like, for example, in living facilities. We anticipate that a girl shouldn't have to share a dorm room with a boy. Yet that is exactly what's happening under these lower court cases and the ACLU's arguments. In addition, there are regulations that are put in place. And those regulations, they're sort of superpower regulations, and that unlike many regulations, they were actually approved by Congress in a particular instance involving whether schools can make sex-based distinctions on the athletic field. This precise issue, They can under the regulations. So Title IX, its history, its context, its language definitely supports that in this context, it's entirely appropriate to make those distinctions between men and women.
It's wild that the statute that was enacted to protect women and girls is now trying to be used. I'm not going to say being used, but trying to be used to attack them. And we're all praying that the court sees through that. I love statistics, so can I just give you a couple?
Yeah.
This is amazing. So this is a contrast from when Title IX, before it was enacted to when after it was enacted. Women playing college sports from 15% of all athletes to more than 50% today. Schools went from an average of 2 women's sports teams to more than 8. I love this statistic, so hang on tight. Female participation in high school sports grew by more than 1,000%. From almost no women's sports scholarships to thousands, and 94% of women in C-suite executives today played sports, and over half played at the university level. We can even do our own poll right here. You're in a C-suite. Did you play sports?
I did.
You're part of the 94%.
I am.
There you go. All right, here's a question, second to last. But it's one that I think our listeners are going to be wondering, and I know that the other side is definitely raising it at least. But it's Bostock, where the court said that an employer who fires someone for being gay or transgender, they violate a separate statute, Title VII. It's going to come up. Do we even touch it? What are your thoughts on that?
Well, I want to be abundantly clear on this. Bostock was wrongly decided,
yes,
and we aim to reverse it.
Amen.
Either effectively reverse it or outright reverse it in time. It was a bad decision and needs to go. But we win anyway. So if you read Bostock, it's very clear. Justice Gorsuch, in the majority opinion, actually says we're not deciding this issue on gender identity or the differences between men and women in any other context than this one under Title VII, which is employment. The language is different between the two statutes. And even more important than that, as I mentioned earlier, the statute itself and the regulations makes sex-based distinctions. So the suggestion that somehow those aren't appropriate under the statute or that boys are similarly situated to girls just doesn't hold up even under Bostock, whether it's its language, its context, its history, or its practical application.
Yeah, and part of that is the difference between employment and sports.
Yeah.
You know, which is the difference between Title VII and Title IX. So as I mentioned earlier, a man and a woman equally qualified, but coming in, applying for a job, there's no reason to treat the two of them differently in that context. That's the Bostock context, the Title VII context. But Title IX recognizes that men and women, boys and girls are different when it comes to athletic opportunities, when it comes to playing sports. You mentioned stats earlier. I've got a few stats.
Go for it.
I mean, we know generally that male athletes are larger, stronger, faster, more muscular than women and girls. Males have 60% to 100% greater arm strength than women, 25% to 60% greater leg strength. They're 10 to 13% faster. They throw further, hit harder, kick faster and farther than females on average, et cetera, et cetera. And Title IX and the Equal Protection Clause both allow states to consider those real differences and take them into account when making decisions about athletic opportunities.
All right, final thoughts.
Well, you want to go first?
Sure.
Yeah. Go for it.
Yeah. So my final thoughts, as I'm thinking about what we're going to hear in the courtroom. Chris and I will both be in the courtroom listening to the justices. So maybe I'll keep my answer a little more in the legal weeds.
Sure.
And so I'm particularly curious, just to start with Hecox. Obviously, we know mootness is going to get a lot of questions from the justices. I would like to hear the justices really concerned about the gamesmanship angle. So I'm hoping to hear a lot of hard questions for the other side about the Pandora's box that accepting their position would open for other cases. On the merits, I'd like to hear the justices pressing the other side on the fact that they're really contorting the whether it's rational basis or intermediate scrutiny, those tests into something that's much more like strict scrutiny, and that would effectively be the end of women's sports, like we said, if the court allowed that and followed them down that path. So those are some of the things. In B.P.J, I'm hoping that the questions will be on the broader level that Title IX and the Equal Protection Clause require, instead of getting into the really nitty-gritty details about the individual case that we have. We think we win on those individual details, as we've seen from B.P.J displacing, I think, girls 700 times was the number that I saw, a lot of times. But really, the implications of this case are much broader, and the legal test requires the discussion, the analysis to occur on that broader basis. And so that's what I'm hoping to hear from the justices, kind of on a legal level.
Yeah.
It is 1,100 times.
1,100
times.
times.
Britt says 1,100
It's
times.
good.
And it has, and I think that makes an important point because as the years have passed,
Right.
so has the numbers.
Yeah.
And that's just because when a boy grows up,
Yep.
he grows stronger.
Yep.
That's just how God made us. So
That's one statistic. I have other statistics.
there are so many statistics. I mean, we can look at the United Nations report. We
Yep.
just again and again and again of how this is affecting women in sports. But I think in terms of final words from my perspective, I would take it back to the real victims. I think as lawyers, we tend to appropriately think about what are the changes that are needed in law? How does the law apply? But we sometimes forget that a cause-oriented perspective forgets the real human victims in this.
Yeah.
And when the law doesn't recognize biological distinctions, it is women and girls who will suffer the most. And that is playing out in real time. And as believers and just as humans, we have an obligation to stand up for truth. So when we're thinking about what's going on in this courtroom, it is a contest for truth that is going on, much more so than athletic opportunities. And the last thing that I do want to say in terms of that contest is, it is a contest that is not just being waged by Alliance Defending Freedom. It is being waged by those who are watching this right now, whether it's in their legal professions, in their capacity as business owners, whatever capacity you're in, you're waging this battle in a contest for truth. And we all have a role to play, and that's a great privilege and a great responsibility.
Amen. Amen. As you just heard, these cases are about more than sports. They're about whether the law can continue to recognize biological reality while protecting women. And at ADF, we're closely monitoring these and similar issues. In fact, we're in the fight on a lot of them. So follow us, including on our social media pages, for ongoing updates and analysis. Thanks for joining us.